Good day, class, and welcome to chapters 5, 6, and 7 of the Law on Sales. So these are the last chapters on the Law of Sales. So let's begin. So let's talk about the principal obligations of the vendee. The principal obligations of the vendee are, number one, to accept delivery. Number two, to pay the price of the thing sold. And number three, to bear the expenses for the execution and registration of the sale and putting the goods in a deliverable state, if such is the stipulation. All right, so number three is if it is the stipulation of the parties, but primarily it is to accept delivery and to pay the price of the thing sold. What are the pertinent rules? Number one, in the absence of any agreement, the vendor is not bound, is not required to deliver the things sold until the price is paid, nor is the vendee required to pay the price before the thing is delivered. So let's remember, class, no, a contract of sale is a reciprocal obligation. There's a reciprocal obligation as between the buyer and the seller. So in the absence of any stipulation, neither party incurs in delay. All right. If if no party is ready to fulfill his or her part of the contract. Okay? So pag hindi nagkikibuan yung seller or yung buyer, tapos wala silang usapan kung kailan ang delivery, kung kailan ang payment, neither of them incurs in delay. One party will be in delay if, for example, the seller is ready to deliver the thing, but the buyer is not ready to pay. So merong dong delay on the part of the buyer. Okay? Balik na rin natin. What if the buyer is ready to pay, but the seller is not ready to deliver the thing? Now, there is now a delay on the part of the seller. Okay? But if neither party is ready to fulfill his or her part of the contract, neither party incurs in delay. Sabihin, walang delay dyan. Okay? Number two, if stipulated, then the vendee is bound to accept delivery and to pay the price at the time and place designated. Okay? So kapag pinag-usapan naman na yung buyer ay dapat magbayad sa ganitong panahon, okay? So dapat yung buyer, kahit hindi pa siya bayad, alright, tapos nagde-deliver na sa kanya yung seller, the buyer should accept. Kasi yun yung usapan nila. Alright? So again, no, very clear na if stipulated. When we say if stipulated, right, it means na pinag-usapan. If there is no stipulation as to the time and place of payment and delivery, the vendee is bound to pay at the time and place of delivery. Number four, if there is also no stipulation as to the place of delivery, it shall be made wherever the payment shall be made, where the thing may be at the time of perfection. So class, no, where the thing may be at the time of perfection. In the absence of a stipulation as to time and place of payment and time of place of delivery. So where the thing is, where the specific thing is at the time of perfection of the contract. If only the time for delivery of the thing is fixed in the contract, then the vendee is required to pay even before the thing is delivered to him. So what are the rules governing delivery and installments? The general rule is the buyer is not bound to receive delivery of goods in installments. Alright, so dapat kumpleto. Okay, hindi mo pwedeng pilitin ang buyer. No, ito parang in Tagalog dialect. Hindi pwedeng in Quezonian Tagalog dialect. Hindi pwedeng utay-utay. Alright? Hindi pwedeng utay-utay ang delivery sa buyer. The buyer cannot be made to cannot be compelled to accept delivery in installments. All right, so it should be given as a whole. All right. So similarly, the buyer has no right to pay the price in installments. Hindi pwedeng pilitin ang seller, all right, na tumanggap ng installments. The seller has to agree to that. O in the same case, yung buyer, okay, yung pwede lang mag-deliver ng object sa buyer in installments kapag payag yung buyer. Otherwise, hindi siya pwede pilitin. So the exception here is unless otherwise stipulated by the parties. So class, that's clear, no? So yung seller, kapag kulang yung binabayad sa kanya, he has the right to refuse to accept the payment kasi kulang. Alright? In the same way, yung buyer, kapag kulang yung binibigay sa kanya, he has the right to refuse to accept delivery. Alright? The exception is if the parties agree. Alright? For the sake of convenience, etc. So that is the exception if payag yung parties. If the breach is material, that it affects the whole contract. If the seller makes defective deliveries or the buyer wrongfully neglects or refuses to accept delivery or fails to pay, the injured party may sue for damages for breach of the entire contract if the breach is so material that it affects the contract as a whole. Now, what do we mean when we say the breach is so material? Sabihin mo, malaki ang sira? Well, something like that, alright? But hindi basta may sira or whatever. Parang i-refuse na yung delivery. Okay? The defect has to be material. So it has to be really significant that it affects the contract as a whole. What if the breach is divisible? It will merely give rise to a claim for compensation for the particular breach, but not a right to treat the whole contract as broken. Okay, but that's only if the breach is divisible. So let's talk about the buyer's right to examine the goods. The ownership of the goods shall be transferred only upon actual delivery to the buyer, subject to a reasonable opportunity of examining them. All right, so the buyer should be given the opportunity to examine the goods. If the seller refuses to allow opportunity for inspection, the buyer may rescind the contract and recover the price. So class, this is important. No? Pag ayaw ng seller na bigyan ng opportunity yung buyer na examine yung goods, no, there's something wrong with that. So in that case, the buyer may rescind the contract of sale and recover any payment he has made. So, pero ito yung caveat for the buyer. Such opportunity to examine must be availed of within a reasonable time in order that the seller may not suffer undue delay. So ito rin yung importante class. No? Hindi mo pwede bigyan ng unlimited time yung buyer na mag-inspect. That is too inconvenient for the seller. All right? So the law wants protection for both parties. Kapag hindi binigyan ng seller ng opportunity yung buyer na mag-inspect, mali yun. Pero mali din naman na it will take for the buyer to examine and inspect the goods forever or for a really long time. Mali yun. That is too prejudicial for the interest of the seller. Okay? So walang hard and fast rule dyan. Walang sinasabi ang batas na specific time for inspection, no? Because it will depend on a number of circumstances. Ang sinasabi sa batas ay dapat reasonable time. Okay? So reasonable time may differ among different objects. Pwedeng iba yung reasonable time sa fruits, iba yung reasonable time sa vegetables, iba yung reasonable time sa other stuff like, for example, books, etc. So iba-ibang reasonable time ng mga yan. Can there be a waiver of right to examine before payment? Actually, yes. Okay. Right of inspection may be waived by stipulation, whether expressly or impliedly. Okay. So if you are the buyer class, you want to make sure that you're not waiving your right to inspect the goods. Okay? Kasi kung sumenyas ka na ayaw mo na inspection yan, then it is deemed that you have waived your right to inspect the goods before payment. Notice to seller of breach of promise or warranty. The buyer must give notice to the seller of any breach of promise or warranty within a reasonable time. All right? So again, we see here reasonable time. Kasi iba-iba yan per so na case-to-case basis. Time is counted not from the time the buyer knows of the defect, but from the time when the buyer ought to have known it. So this provision is very important, class. Okay? So hindi ibig sabihin na dahil hindi alam ng buyer na may defect pala. Okay? Hindi ibig sabihin no, na dahil hindi niya alam na meron defect ay hindi ay pwede pa siya na magbigay ng notice sa seller para i-refund siya or what, no? So time is counted from the time when the buyer ought to have known it. Sabihin, mula sa time na dapat nalaman niya may sira pala. Okay? Kasi what if, class, let's say bumili ka ng kotse, brand new, no? Tapos yung kotse pala na yun ay parang let's say hindi mo naman ginagamit, no? Let's say naka-stock lang sa garahe mo for let's say 2 years. Tapos yun pala may problema yung let's say yung engine, may hidden defect yung engine. Right? Let's say tapos nalaman mo lang in 3 years time. Tapos ngayon gusto mo mag-claim ng warranty. Okay? So class, pag ganun, hindi pwede yun. Hindi mo pwede sabihin, teka, hindi ko naman kasi alam for the past 2 years na may sira pala yan. Yung pala nalaman. Hindi yan pwede. Alright? So, again, it's important to note here that time is counted from the time when the buyer ought to have known the defect. So, dapat malaman niya, yung time, magagaling sa time na dapat nalaman niya na may sira talaga. Hindi yung actual knowledge niya. The purpose of this is to protect the seller from belated claims and for the seller to be able to take immediate steps. So there are 2 reasons. It's to prevent fraud. Kawawa naman yung seller kapag nag-claim ka na masyadong matagal na. Because hindi na malalaman kung ano talaga yung cost ng sira. Alright? And for the seller to take immediate steps. Kasi pag mas naluluma ang isang bagay, talagang dumadami ang sira niyan. Minsan, medyo mahirap na ayusin. Okay? Pero kung medyo bago pa yan, maayos pa yan ng seller. Where the buyer's refusal to accept goods is justified. So we discussed earlier that it is the buyer's duty to accept delivery. But in these cases, the buyer's refusal to accept goods is justified. Number 1, the buyer has a duty to take care of the goods, but he has no obligation to return the same. The buyer is in the position of a bailee. Alright? So, class, no? So, ang sinasabi dito, pag justified yung buyer na hindi tanggapin yung goods, let's say kulang yung delivery or parang let's say mali yung dineliver sa kanya. Right? Hindi obligation ng buyer na ibalik yung goods. Obligation siya kunin ng seller. Alright? So yung buyer nasa position ng bailee. So what is a bailee, class, no? What is a contract of bailment? So para tong hiram, no? Parang kumbaga nasa position yung buyer na parang hinihiram lang niya. Yung ano, hinihiram lang niya yung para nasa kanila yung possession, yung gamit. Alright? Pero hindi na pwedeng, ano, hindi na pwedeng exploit yan. Number two, after notice, the seller has the burden of taking delivery of the goods. So the buyer has to notify the seller to take delivery of the goods. Number three, the loss of the goods are at the seller's risk unless the buyer agrees to be liable as a depositary. Okay? So, kahit yung goods na sa possession ng buyer, they are still at the risk of the seller class. Okay? Let's say yung mga goods na justified yung buyer na hindi siya tanggapin. Let's say yung goods na yon nasa bahay ng buyer. Tapos let's say binaha yung buyer or ninakawan siya, the risk of loss is still with the seller. Right? Unless pumayag yung buyer na maging liable siya as a depositary. Right? Pero syempre, dapat wag papayag yung buyer na gano'n. Right? Number four, if the seller fails to take delivery of the goods, okay, the buyer may resell the goods. All right? So given yung buyer ng ganitong power, all right? But only if the seller fails to take delivery of the goods. Bakit may ganitong power yung buyer? Because class, it's also burdensome, no? Na maghawakan ng gamit ng ibang tao. You don't want to do that. Some people would probably want to do that, no? Yung gumagamit siya, meron siyang gamit ng ibang tao. You don't want that. It's also costly to hold so many goods. Effect of buyer's wrongful refusal to accept. The risk of loss is borne by the buyer from the moment the goods are placed at the buyer's disposal. So class, naibahin natin ito sa previous slide. Sa previous slide, justified yung buyer na hindi tanggapin. So dito, class, hindi justified yung buyer na hindi siya tanggapin. Ngayon, pag ganun, pag niya-deliver sa kanya, tapos wala naman siyang valid reason not to accept delivery, the risk of loss is now burdened by the burden of loss is now imposed on the buyer. Okay, it's now borne by the buyer. Liability of vendee for interest where payment is made after delivery to the vendee. Number one, if interest is expressly stipulated. So kapag pinag-usapan class, no, na pag na-deliver na yung gamit sa buyer, tapos yung buyer hindi pa nagbabayad. No? So if interest is expressly stipulated. Number two, when fruits or income are received by the vendee from the things sold. Number three, if the vendee incurs in delay, interest is due from the time of judicial or extrajudicial demand by the seller. So class, kung mapansin nyo, no, itong number one is kapag pinag-usapan ng buyer and seller. Itong number two at saka number three, this is by operation of law. So hindi yan kailangan pag-usapan ng parties. Alright? So yung number two, when fruits or income are received by the vendee from the things sold. No? Pag ganyan yung situation, the buyer or the vendee is obliged to make interest payment to the seller. Alright? So when can the vendee suspend payment of the price? Number one, if the vendee is disturbed in the possession or ownership of the thing bought after final judgment. So class importante after final judgment. No? Or if he has a well-grounded fear that his possession or ownership would be disturbed by a vindicatory action or foreclosure of mortgage. All right? Okay, so sabihin, for example, class, no, nagbabayad ka ng ng installment sale ng real property. Alright? Or bibili ka ng property. Tapos kinasuhan ka. Bakit ka kinasuhan? Kasi yung pala, yung seller mo, binenta siya beforehand sa ibang tao. Tapos yung taong yon, mas may right pa pala kaysa sa'yo. No? So ang ginawa nung tao, kinasuhan ka to evict you. Alright? Kaya nag-decide yung court. So talo ka. Yung isang tao na yan na bumili ng property. So in that case, class, no, the buyer can suspend the payment of price. Pwede yan hindi bayaran yung yung seller dyan. Number 2, if he has a well-grounded fear that his possession or ownership would be disturbed by a vindicatory action or foreclosure of mortgage. Alright? So class, no, in that case, pag i-foreclose na pala yung property na binibili mo, pwede kang mag-suspend ng payment. Alright? Kasi pag foreclose yan, yung ownership niya, baka mapunta na sa ibang tao. So when the vendee cannot suspend payment of the price, even if there is disturbance in his possession or ownership of the thing sold. So ito class, ito mga circumstances na to, sabihin, hindi pwedeng mag-suspend ng payment ang buyer. Alright? Kahit mayroong disturbance in possession or ownership. Okay? Sa mga cases na to, hindi pwede mag-suspend si buyer. Number 1, if the vendor gives a security for the return of the price in the proper case, if it has been stipulated that notwithstanding any contingency, the vendee must make payment. So no matter what, so dapat magbayad pa rin. Number 3, if the vendor has caused a disturbance or danger to cease. Ibig sabihin, parang naareglo na yung kaso, wala nang danger. No? So pag ganyan, magbabayad pa rin dapat ang buyer. Or if the disturbance is a mere act of trespass. So class, na parang kapag may dumaan lang or whatever, it should not cause the buyer it should not justify the buyer to suspend payments to the seller. Okay. Number 5, if the vendee has fully paid the price. Kasi bayad na. No? Hindi naman yung para i-refund pa. When the vendor may rescind sale of immovable property. So again, class, we're encountering rescind. No? Rescind means cancel. Right? So we also learned this in Omnicon. If the vendor has good reasons to fear the loss of the property and the price. There has been delivery of the property, but the vendee has not paid the price. So class dito, vendor yung may power to rescind. No? Vendor. Applicable to both cash sales and installment sales of real property. Alright? So pag yung buyer hindi binabayaran yung presyo, no? So that's too prejudicial on the part of the seller naman. So you have to protect the seller. So the seller, ang dapat pala dito, yung kapag meron ng delivery ng property, tapos hindi pa rin nagbabayad ang vendee. So in this case, the vendor has the power to rescind the contract of sale of immovable property. Right? Paano kasi pag walang usapan sa date ng delivery, tapos hindi pa rin nagbabayad yung yung buyer. Alright? Pwede ba ito i-rescind? So class, in this case, no? In this case, under Article 1191, so again, contract of sale is a reciprocal obligation. Neither party incurs in delay. Okay? So isabihin, kumbaga, parang hindi pa sila pwede magkasuhan talaga. I mean, neither party incurs in delay unless merong usapan na dito magbabayad, dito magde-deliver. Okay, one party is already willing to pay or the other party is already willing to deliver. Tapos hindi pa rin gumagalaw yung isa. Doon pa lang pwede kasuhan. Doon pa lang magkakaroon ng delay. Where automatic rescission of sale of movable property is stipulated, the vendor must always make a demand for rescission before he can have the right to rescind the contract. Alright, so dapat meron palaging para notice, no, or demand for rescission. Rescission can be had if the vendee does not accept delivery, alright, or if the vendee does not pay the price unless a credit term has been agreed upon. So let's talk about seller's right of action for the price. When the ownership of the goods has passed to the buyer and the buyer wrongfully neglects or refuses to pay for the price. Number two, when the price is payable on a certain day and the buyer wrongfully neglects or refuses to pay. It does not matter if there has been delivery or transfer of title. Right? Number three, when the goods cannot be resold for a reasonable price and the buyer wrongfully refuses to accept them even before the ownership in the goods has passed to the buyer. When ownership in the goods has not passed, the general rule is the seller cannot maintain an action for the price if the goods have not passed to the buyer. So what are the exceptions? If the price is payable on a certain day, or if the goods cannot be readily resold for a certain price, and the buyer wrongfully refuses to accept them. So let's talk about the seller's right of rescission before delivery. When the buyer has repudiated the contract of sale. So again, class, this is dito papasok yung right ng seller to rescind, no, before delivery of the object. When the buyer has repudiated the contract of sale, sabihin parang what does repudiated mean? Parang ano, not really baliwala, no, parang ino-oppose niya, parang sinasabi niya na ano na hindi totoo yan, mali yan, ganyan. So that is repudiated. When the buyer has manifested his or her inability to perform his or her obligations therein. When the buyer has committed a breach of the contract of sale. So class, no, again, this is before delivery. Even before delivery, pwede na mag-rescind yung seller. Right? So, but the seller is required to give notice of his election to seek rescission. Hindi basta pwede i-rescind na. The seller has to give a notice of rescission. What are the remedies of the buyer for breach of warranty by the seller? So in this case, class, no, the remedies are alternative. Only one is allowed, right? So the first remedy is to accept the goods and set up the seller's breach to reduce or extinguish the price. So pwedeng tanggapin pa rin yung goods, tapos tapos bawasan na lang yung presyo. Yun, no? So ang pipili ng remedy na to is yung buyer. Number two, accept the goods and maintain an action for damages for the breach of the warranty. Right rin to. Kasuhan niya yung seller for the breach. Pero accept pa rin niya. Number three, refuse to accept the goods and maintain an action for damages for the breach of the warranty. So again, class, no, pag mali yung product na binibili mo pala, tapos you're not at fault, you can refuse to accept that. You can refuse to accept the product. You can refuse to accept the goods. Rescind the contract of sale by returning or offering the return of the goods and recover the price. Alright, so pwede to, na-solve mo yung gamit. When rescission by the buyer is not allowed, number one, if the buyer accepted the goods knowing of the breach of the warranty without protest, right? So this will have to be proven, class. No? So again, if the buyer accepted the goods knowing of the breach of warranty, so kung alam naman ng buyer na may sira yan, tapos hindi naman siya nagreklamo, tapos binili pa rin niya, right? Hindi pwede ang rescission dito. Number two, if he fails to notify the seller within a reasonable time of his election to rescind. Again, class, no, papasok ulit dito ang reasonable time. Okay? So the buyer has to notify the seller within a reasonable time, right? If the buyer wants a rescission. Kapag lampas reasonable time na, hindi na pwede. If he fails to offer or return the goods in substantially as good condition as they were in at the time of the transfer of ownership to him. So kapag nagamit na yung product tapos hindi na siya in good condition, hindi na pwede ang rescission. So rights and obligations of the buyer in case of rescission. The buyer shall cease to be liable for the price, his only obligation being to return the goods. If he has paid the price or any part thereof, he may recover it from the seller. He has also the right to hold the goods as bailey for the seller should the latter refuse to return, should the latter refuse the return of the goods. Okay? Kapag yung seller hindi na ayaw tanggapin ulit yung goods na binenta niya. So the buyer has the right to hold the goods as bailey for the seller and until nakuha ng seller yung goods. Therefore, he has the right to have a lien on the goods for any portion of the price already paid, which lien he may enforce as if he were an unpaid seller. All right. Class, let's go to the next chapter. No? Let's talk about conventional redemption. But when you say conventional, what does that mean? When you say conventional redemption, ito yung pinag-usapan ng mga parties, pinag-usapan ng buyer at saka ng seller. Alright? Pinag-usapan nila kasi nangyayari sa conventional redemption class, it's a sale with the right to repurchase. Okay, for example, ikaw, binibenta mo yung property mo, yung bahay mo, sa kaibigan mo. Pero ang usapan nyo, teka pare, kasi mahal ko yung bahay ko. Ibebenta ko yan on the condition that I have the right to repurchase that property in 5 years. Sabihin, pag gusto ko ulit bilhin yung property niya, ito, payag ako na ibenta sa yung property niyan. But give me 5 years to exercise, give me 5 years, give me an option of 5 years to have the right to repurchase that same property. Pwede ba yung class? Yes, pwede yun. Bakit siya ginagawa, class? Well, syempre ginagawa siya kasi minsan kailangan ng pera, di ba? So, minsan ibebenta mo yung bahay mo. O ibebenta mo yung ibang properties mo. But you want to have the right to repurchase that said property. Alright? So, you will learn later on na may maximum number of years to, no? That you can have the right to repurchase. Hindi yan pwedeng forever. Because that's too burdensome. So anyway, no, the maximum limit that you can set up is 10 years. Hanggang 10 years lang pwedeng usapan yung na right of repurchase. So conventional redemption, a right of the vendor to reacquire the property sold provided he reimburses the vendee of the price. The right to redeem must have been reserved by the vendor to himself. Alright? So, importante yung class. No? Kasi kung walang usapan na may conventional redemption, hindi pwede. Okay? Once you sold your property, okay, tapos wala kayong usapan as regards right to repurchase, hindi mo pwedeng pilitin yung buyer na bilhin ulit yan. Kasi property na niya yun. Okay? So, kung gusto mo magkaroon ng right to repurchase, dapat alam yan ng buyer mo. Dapat nasa usapan niya. What is equitable mortgage? So, we already know what mortgage is. No? Mortgage is sangla. Bakit ka nagsasangla? Kasi umuutang ka. You want to get money, you enter into a contract of loan. Then as an accessory contract, you enter into a contract of mortgage. Para nagsasangla ka na in case hindi mo bayaran yung loan mo, i-foreclose yung property mo, yung naka-mortgage. I-foreclose yung mortgaged property mo. Then it will be sold to the highest bidder. Then yung proceeds, i-apply dun sa utang mo. And class, meron tayong tinatawag na equitable mortgage. Right? So class, meron mga sale with right to repurchase na medyo kahina-hinala. No? Kasi minsan ang baba ng presyo masyado, ganyan. Yung pala, ang intention talaga ng seller is umuutang lang siya. No? Wala siyang balak talaga na ibenta yung property niya. Right? Hindi na balak ibenta talaga yung property niya, pero dahil gipit sa pera, sabi niya, o pare, bilhin mo muna yung bahay ko, pero bibilhin ko ulit yan sa'yo. Ganyan. So the law class, no? The law considers that an equitable mortgage. Right? So it lacks the formalities of a mortgage, but it shows the intention of the parties to make the property subject of the contract as a security for the fulfillment of an obligation. So a pacto de retro sale is a sale with right to repurchase. So in case of doubt, it is an equitable mortgage. The remedy is a reformation of the contract. So imbis na contract of sale talaga yan, imbis na dito sale, dapat parang mortgage talaga siya kasi wala talagang balak yung seller na magbenta. So bakit merong ganyang class? At pinipigilan pa yung seller na magbenta? It's to protect the debtor-seller class. No? Alright? Kasi minsan, kahit ano gagawin yan para magkapera. So minsan yung ganyan tao, naaabuso. Naaabuso ng mga lending companies, etc. etc. Alright? So so the law deems the need to protect the interests of the debtor. It's also important to prevent circumvention of usury law. What is usury law class? No? Sa Philippines ngayon, the usury law is suspended. Right? Ibig sabihin ng usury law, bawal mag-impose ng sobrang taas na interest rates. Right? Mapapansin niyo class, no, meron mga lending companies or may mga tao nagpapautang, tipong 10% per month, 20% per month. Alright? So, if the usury law is not suspended, bawal yung ganong kataas na interest class. No? Here's an amazing theory class. Here's an amazing historical fact. In the Islamic world, no, in the Ottoman Empire, in the Ottoman Empire's early history, may mga lenders. Pero parang bawal sila mag-impose ng interest. No? So yun, no? Kasi it's deemed too greedy. Parang ganyan. Pero right now in the Philippines, the usury law is suspended. Right? So kung nagpapautang kayo, pwede kayong magpautang na kahit sobrang taas na interest rate. But then again, class, so pag hindi makabayad yung pinautangan nyo, tapos kinasuhan nyo, pwede babaan ng courts yung interest. Alright? So the courts have the power to reduce the interest rates if they are unconscionable. Kasi unconscionable, masyadong mataas na it's shocking to the senses of man. Paano kung ang interest na hinihingi mo dun sa pinautang mo ay 100% per month? Masyadong mali naman yan. So, the price and pacto de retro sale is usually the price and pacto de retro sale is usually lower. Alright? So, pag ganyang mababa yung price sa pacto de retro sale, usually equitable mortgage yan. So here are the factors used to determine if the contract is an equitable mortgage instead of a sale with a right to repurchase. When the price of the sale with right to repurchase is unusually inadequate. Okay? Hindi porke mababa lang, ay equitable mortgage na yan. Alright? So the wording here is unusually inadequate. Kumbaga, nakaka-shock yung presyo masyado na it cannot be considered as a sale. No? Kasi masyadong lugi yung seller. Alright? So pag ganyan, pag sobrang baba pala ng presyo, yung pala equitable mortgage pala yan. Ang purpose lang talaga nung seller ay nangungutang lang. When the vendor remains in possession as lessee or otherwise, yung possession of property nasa vendor pa rin. When upon the expiration of the right to repurchase, another instrument extending the period of redemption is executed, right? When the purchaser retains for himself a part of the purchase price, when the vendor binds himself to pay the taxes on the things sold. So class, no, ang sinasabing taxes dito, yung real property taxes. Sino ba nagbabayad ng real property taxes? Ang isang property, edi yung owner, no? So ganito, so let's say kahit binenta ng kahit for example binenta kunwari ng vendor yung property niya, pero siya pa rin yung nagbabayad ng real property taxes. The presumption there is it could be an equitable mortgage. When it can be inferred that the real intention of the parties is to secure the payment of debt, right? So again, class, imagine, let's say umuutang kayo. Tapos ang daming pinapapirma sa inyo ng lending company or nagpapautang. Yung pala, pinipirma mo na contract of sale. Tapos with right to repurchase. Okay? Pag ganyan class, tapos sobrang baba nung pautang niya sa'yo. Tapos kunwari yung ginamit mo na parang security ito sa utang, the law will deem it as an equitable mortgage. All right? So let's talk about the period to exercise a right of redemption sa conventional redemption class. If there is no agreement granting the right to repurchase, there can be no right of redemption. It is an absolute sale. All right? So class again, no, yung right to repurchase, it has to be reserved by the vendor or the seller. Okay? Kasi pag walang ganyang usapan ng parties, hindi pwedeng kunin ulit ng seller yung binenta niyang gamit. Okay? Kahit yung let's say kakabenta pa lang, tapos talaga may usapan na maayos. Hindi pwedeng pilitin na bilhin ulit yung goods, yung good na binenta niya. Alright? Number 2, if the agreement merely grants the right to repurchase, let's say merong right to repurchase yung seller, pero walang stipulation as to how many years. The answer there is, right, 4 years from the date of the contract. So the seller, a retro, yung original na nagbenta, the seller is given a period of 4 years within which to buy back the property. But then again, dapat merong nakasulat na right to repurchase. Wala lang nakasulat na number of years. Para kung nakasulat, the seller has the right to repurchase within 1 year from sale. Edi 1 year, right? So what if there is a definite period agreed upon? It must not exceed 10 years. So in class, it's under Article 1606 of the Civil Code. All right? If may pinag-usapang period, it must not exceed 10 years. Hanggang 10 years lang yung right of redemption, yung right to repurchase. Okay? What is the purpose of that? Bakit meron 10 years na limit? Because it's too prejudicial to the interest of the buyer naman. Kawawa naman yung buyer na habang buhay siyang mag-iisip kung i-buy back pa, kung i-repurchase ba ng seller yung property. So the law actually frowns upon that. No? So kung meron pinag-usapan na right to repurchase, dapat maximum 10 years lang. So here is the reasoning for limiting the period of conventional redemption. It is for the purpose of public interest. It is to prevent uncertainty of tenure of property. Okay. So what class is legal redemption? Legal redemption, it is different from conventional redemption in the sense that conventional redemption is agreed upon by the parties. Legal redemption is by operation of law. All right? So kahit sa gusto o ayaw ng mga parties, the law provides for legal redemption. So right of legal redemption of co-owner. All right? So you already know what co-ownership is. So dito papasok yung yung existence ng right of legal redemption ng co-owner. Number one, there must be a co-ownership. So you imagine a co-ownership class na let's say real property. Ang may-ari magkakapatid na minaran nila sa parents nila. Number two, there must be alienation of all or any of the shares of the other co-owners. Okay? Let's say binenta yung yung shares ng mga co-owners, no? Or yung isang co-owner nagbenta lang ng share niya. The sale must be made to a third person or a stranger. Bakit meron dito third person or stranger? Ang third person or stranger, sino ba yon? Yun yung hindi co-owner. Alright? Kasi pwede yung class, let's say co-owner ka, pwede mo ibenta yung share mo sa ibang tao. To strangers. Okay? Pag sa co-owner mo binenta, hindi stranger yun. Right? So, walang legal redemption kapag binenta mo yung share mo sa co-ownership sa co-owner mo mismo. There is no legal redemption in that case. Bakit walang legal redemption in that case? Because the law actually the law wants to limit co-ownership. The law actually wants to prevent co-ownership kasi magulo ang co-ownership class. Okay. Therefore, the sale must be made before partition. Alright? So class, no, any of the co-owners may demand for partition of the property. Yung paghahati-hatian nila kung kanino sa kanila. Ngayon, pag na-partition na yan, no, tapos binenta ng isang owner, no, binenta ng isang owner yung property niya, hindi na yung pwede habulin ng ibang co-owners. Kasi naka-partition na, nakahiwalay na. Number 5, the right must be exercised within the period provided, which is 30 days from notification of the sale in writing by the homeowner. So this is important class. No? The right must be exercised within the period provided, which is 30 days from notification of the sale in writing. So remember this class. No? Pag lumampas na, hindi na pwede. Number 6, the vendee must be reimbursed for the price of the sale. So class, we end here. So keep safe. God bless and take care.